The government has increased the monetary threshold for filing appeals in cases of tax disputes. The government says that this move is aimed at reducing litigation in courts across the country. That's not all. The tax department will now follow these guidelines retrospectively in a manner and withdraw many pending appeals as per these new thresholds. So here's how the new levels actually stack up. The Central Board of Direct Taxes and the Central Board of Indirect Taxes and Customs, the CBIC, can file appeals at the tribunal level only if the tax amount involved is 20 lakh rupees or more, as opposed to the earlier limit of 10 lakh rupees. Now, moving on to the cases which are pending in higher courts, the monetary threshold there has been increased to 50 lakh rupees as opposed to the earlier limit of 20 lakhs. Now, for filing appeals in the Supreme Court, the amount involved should be at least 1 crore rupees. Earlier, this was just 25 lakh rupees. So now it's gone all the way up to 1 crore rupees. So can this move ensure that the resources of the Revenue Department are utilized in a more efficient manner, that they actually target the more important cases? And also, could it perhaps give a fillip to the ease of doing business? That's the question that we will put forward to our panel of experts. We have with us Dinesh Kanabar, CEO of Dhruva Advisors, joining in. Girish Vanwari, founder of Transaction Square, is also with us. And Rahul Garg of PwC India, also joining in the conversation. Gentlemen, good evening to you. Thanks very much for joining in. Mr. Kanabar, first thoughts with you. The government claims that it's a big step forward. Is it?
It really is a big step forward, Surbi, because what has been happening today is that every single matter on which there is a addition made goes up at the tribunal, and then from there on to the High Court and the Supreme Court. And normally, matters get litigated in courts only if there are questions of law. Questions of fact can be litigated before the court. But every attempt is made to classify every matter as being a question of law. As a result of this change, what will happen is, A, the burden will come down. Today, there is a huge pendency of litigation. It takes anywhere between 4 to 5 years for a matter to be heard from a commissioner of appeals to a tribunal. Even larger time depending on which High Court you are talking to, for matters to go from tribunal to High Court and to Supreme Court. Once the number of matters go down, it will bring down the quantum of litigation. It will mean that the courts will be burdened less with smaller items which they don't need to. The disposal time will be therefore quicker, and therefore matter will be more contemporaneous. It does not make sense today to argue a matter relating to 15 years back before the courts. And therefore, this is a very, very welcome move.
Okay. Actually, I want to throw in some more numbers. We should perhaps pull up those graphics, what the government's claim is, because of the appeals that are going to be withdrawn from various high courts and different tribunals. So for the CBDT, across the ITAT, across the various high courts of the country, the government says that litigation is actually going to go down by 41%. For the CBIC, it's going to drop by almost 18%. Now, that's, of course, what the government is saying because of simply the appeals that will be pulled away. Let's also bring in Mr. Vanwari into the conversation. What are your thoughts, sir? And, you know, are the threshold limits now far more realistic? Will they serve the purpose?
So the thing is that the threshold limits are getting revised after 3 years now. So 2015 was when the last revision was there. So clearly, this threshold limit will free up a lot of time. You know, if you look at all the litigation data and if you look at all the data going for the new tax code which is being spoken about, people speak about getting the litigation to a lower number. Now, also there are claims being made that around 12 lakh crores are stuck in litigations and people are not able to solve them quickly so that the tax office cannot collect the money first. So if you free up the time by this kind of a notification wherein you drop the inessentials, you drop the ones where the collections cannot be much, then you actually can focus on the bigger litigation, try and resolve them, and hopefully collect the taxes, if any, collectible on those litigations, and thereby improve the tax collections. So I see a double advantage. First of all, harassment will go away and people running behind smaller amounts will not be able to waste time anymore on these kind of things. And second is also energy will get diverted to resolving the bigger ones and bringing in more certainty for the Indian corporates and thereby leading to better tax situations. So overall, much needed and lots to be achieved through this move.
Sure. Rahul, your thoughts? Could this actually be, the end of that much used and abused phrase, tax terrorism?
I think it's very clearly, it was set up some time back, as Girish mentioned, the limits were raised now. But to my mind, there's a very fundamental issue here, that when we talk of the limits to be put on the tax department to litigate, we are saying that we are wanting the tax department as a revenue office to litigate a matter which has been decided either by another revenue officer or by a machinery of the court. So if we have a reasonable faith and trust in the machinery of the court and in the tax department's officers who decide either as a DRP or CIT appeals the matters which come to them, I see no reason for, in the first place, for the revenue to file an appeal. So to my mind, this is definitely a step in the right direction, but in terms of whether the limits are okay or would that eliminate the lot of cases and therefore bring in the advantage that Dinesh mentioned, for sure it would. But to my mind, it must be seen as a move giving way to the thought that an officer's order decided by another officer or another independent court should not then be appealed only because the taxpayer has won it. And we must have a faith in the system, because the citizen is going to take a refuse to the court or the appellate forum. It's not the king or the sovereign which is taking refuse to get a justice there. So to my mind, this is a good beginning, but that's not the end. We must look at a system where there is no need for revenue to file any appeals at all against their own order or the orders of the tribunals and the courts, which are fairly independent.
Okay. Mr. Kanabar, so obviously there is a carve-out, and perhaps rightfully so. I mean, that would be required. Can't have a blanket rule for everything. So this point on, the substantial point of law, and that's where, the appeals will not be withdrawn, and that's where perhaps maybe these rules don't apply. Is that a fair carve-out?
In a sense, by definition, Surabhi, you cannot have an appeal to a high court unless there is a substantial question of law that is mandated in the Income Tax Act itself. I think the concern is that more often than not, as I mentioned earlier too, the revenue prefers to go into appeal to the court on the basis that whatever is decided poses a substantial question of law. And my concern is whether this carve-out will be used by the revenue to bung in appeals on smaller amounts on the basis that it poses substantial question of law.
Exactly.
Let me put one statistic to you, Surabhi, which might be more useful in our discussion. The fact today is that if you look at the appeals before the Income Tax Appellate Tribunal, probably the success ratio that the revenue has is somewhere between 15 to 18%, meaning in 70 to 80% of the matters or more, it is the taxpayer who wins before the Income Tax Appellate Tribunal. Now, what does that show? That shows that litigation, A, is being pursued on frivolous matters. B, the preparation which is being done by the revenue maybe is not adequate. Now, the point which I would like to put on table is that a tribunal is the final arbiter on facts. With the reduction in the workload, hopefully the revenue officers will be able to prepare better, argue matters better, and therefore reach a better resolution. Once that is done, the exceptions should be used really in exceptional cases to go to the court and should not be used as a ruse to take even smaller matters to the high courts.
Okay, absolutely. Girish, your thoughts on this? I mean, this is a beginning for sure, but the government goes on to say this could really help in ease of doing business, etc. What more would you like to see if this promise of doing away with tax terrorism is to actually be carried through and executed properly?
No, actually, I think this is a step in the right direction. As Dinesh said, like if there's a genuine implementation of this the way it's been spoken about, and if energies are diverted to really deal with the bigger issues and solve the bigger issues and thereby increase tax collections and bring in more certainty, it will really be a big boost to the resolution process in this country. And hopefully it will lead to a better tax certainty. So I overall think it's a step in the right direction. Now, whether there's 20 lakhs or 50 lakhs or 1 crore, is it right or should it be higher? That can always be debated. but certainly it's double the previous limit, so this should certainly help.
Okay, Rahul, I have just 10 seconds left on the conversation. Any suggestions that you'd like to make to the government on the matter?
I think it is very simple that first of all, given this experience of now the appeals being withdrawn, I hope it doesn't result in a situation of the appellate authorities, particularly the manned by the revenue or ex-revenue officers, to take a view that because now there is no right of appeal in such cases, therefore the outcome should be different. And we saw some flavor of that when the DRP matters were appealable or not appealable, whether the outcomes were similar or not. So that's one safeguard I would think one should keep in mind. And secondly, we must also look at how do we avoid this altogether, as I said in the beginning, that the revenue should not be filing the appeal at all.
Sure.
And one clear case is if you look at the fringe benefit test, there are no litigations on that. Not just because there were not transactions involved or amounts involved, but
Sure.
because there was so much guidance given in respect of each and every item
Right.
that there wasn't a need for litigation. So I would think that the post facto withdrawal of appeal is not a great thing to do the ease of business. The ease
Sure.
of business comes more from proactively avoiding that situation that precipitates the litigation.
Okay, well, it's a step in the right direction. Our panel of experts is in agreement. Let's hope it builds on that. Thank you very much, gentlemen, for joining in on this special conversation.